There's nothing more powerful than the odor of mendacity.
In a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Leaf.
Respectfully, I take it very seriously.
This is disgusting, but it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
All right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive. And it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need.
I call that video Mad Max because he is mad and with good reason. And welcome back Inside the Law, folks. I'm your host, Philip Holloway. This is the LawTube channel where we're going to take you inside the real justice system to show you what it's really like in real courtrooms in the real world all across America, right? You might think that you know something about the criminal justice system. Maybe you worked in it for almost 30 years like me, but most people haven't. So this is where we show you the real thing, the good, the bad, and sometimes the very ugly. And of course, we do that in the context of real cases that are happening. And it's usually things that are going on in the news, right? There's a lot of politics, a lot of world politics. There's a lot of conflict in the world, lots of things that we could talk about. But this is a LawTube channel. So we're going to talk about the law and things that we can learn from these cases. Thank you for joining us. And if you are new here, thank you for giving us a shot. And look, I hope that you would consider liking this video on the way in, because that helps other people to find this channel. And of course, we want you to subscribe. I'm narrowing in on 46,000 subscribers. And of course, I'm trying to get to 50, but one by one, you can help me by hitting that subscribe button and maybe tell a friend or two. So there's a lot going on in this Fani Willis versus Young Thug trial that we're going to get into today. In a few minutes, our friend Rachel Kaufman is going to help me to break it all down, because as you may know, this is not yet my full-time job. I would love to do LawTube and do streaming full-time, but I'm not there yet. We're growing and we're on the way, and that's why I appreciate your support in this channel. But for now, when I'm not able to watch wall-to-wall coverage, I do my best to try to get up to speed on things that have happened. And sometimes I rely on other people, and it's usually subject matter experts. Now, before we bring Rachel in, I want to say again, welcome to, there's 529 of you in here live. And whether you're watching live or on the replay, I, of course, appreciate you being here. And I want to have you weigh in the comments, join the chat. Okay. Because I will go back later and look at the chat, and I like to see what you're talking about, the things that I might miss. And of course, I like to try to answer questions where I can. And a super chat always gets my attention for questions. All right. what happened today? Well, among other things, the lawyers are pissed. Well, what are they pissed about? They are pissed because overnight or yesterday after court last night, they found out that there was yet another ex parte conversation between the prosecutors in this case and former trial judge Glanville. Glanville, as you know, if you've been following this channel or following this case at all, you know Judge Glanville was ordered to be recused. Initially, he resisted it. He basically flat out said, I'm not going to recuse myself, even though Georgia law requires a motion to recuse to go to another judge. You can't grade your own papers. If the lawyers say you're doing something shady, you need to be recused, another judge is supposed to look at it, but he failed to do that. Well, our friend Doug Weinstein, who you'll hear some from here in a few minutes, and who's the author of this supplemental motion for mistrial that you see on your screen here, Doug went to the Supreme Court of Georgia, and Doug said, look, I want an order from this court ordering this man to follow the law, to send the recusal to another judge to consider. Well, long story short, the Supreme Court did not agree to do that, but in denying Doug's request, they gave some interesting instructions on what needed to happen, nevertheless, and eventually got Judge Glanville to reverse course. He sent the recusal motion to another judge who said, well, maybe the ex parte is okay, maybe it's not, I'm really not sure, but I'm going to recuse Judge Glanville because he didn't follow the right process. So anyway, they kind of punted on it, but nevertheless, we have a new judge. And so now we've got all these motions for mistrial. And yesterday, a lot of them were argued. Today, the motions for mistrial, except for Doug's, the one that you see, or at least part of the one that you see here on the screen, is still under advisement. So we're going to take just a minute and take a look at that. And I'm going to, before I do that, I want to bring in our good friend, Rachel Kaufman, who was actually, I think, in the courtroom some today at the courthouse following all this. And let's big round of applause for our friend, Rachel Kaufman. Rachel, how are you?
Hello, Phil. Yeah, it was a wild day in court. It ended early, but we'll get to everything, I imagine.
Before we get into that, Rachel has some breaking news of her own. Rachel, do you want to break it or do you want me to break it?
Honestly, this is the first place I've broken it publicly. And it's kind of funny. I'm pregnant.
Oh, Rachel's going to be a mother.
Yeah, 38
due
years
on
old.
February.
Yeah, never thought this would happen, but here we are.
Well, I tried to call Rachel earlier and she was understandably taking a nap. Well, congratulations to you. And I want to just go ahead and get that out there and say that publicly. We are so happy for our good friend Rachel, who is also going to be a great mother, but she's a great lawyer first and foremost. And so, Rachel, I want to take just a minute and I want to go through. I'm not going to get it. You've got the transcript. So I'll save the highlights of the transcript for you, with the exception of the ones that Doug put in this supplemental motion for mistrial. And so here's what Doug says. Okay. Doug points out that outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. And he's citing a professor from Berkeley. One thing that I love about Doug's writing, and Doug is, as he'll tell you, he's relatively new to criminal law. He's done a lot of civil litigation. Doug likes to be creative in these things, and he cites non-traditional sources to get his point across. And he goes on to say, Judge Glanville making outrageous allegations against members of the defense teams in the present case, quote, but I think it does in some way outside agitators and everybody else who I think are trying to influence. So this is a quote from apparently Judge Glanville. Now this, by the way, the ex parte that was revealed was from the Friday before Woody, Mr. Copeland, it was on the Friday before the ex parte that we knew about. It was the first day they had Woody there in courts. I think that would have been June the 7th. And so he points out the third ground argued in Kendrick's motion for mistrial, Kendrick being Doug's client. It says due process rights were violated relating to the 14th Amendment due process relating in part to Judge Glanville wrongfully coercing witness Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process has just come to light. Well, in case you are just joining us, this is what Max was so mad about.
This is disgusting, but it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning.
And Max is right about that. This is not about anybody's guilt or innocence. This is about fairness in the process. And what Doug is pointing out, what Max was talking about there in that video is, the judge being not fair and not impartial. And he says yesterday after court, Kendrick received a rough transcript, Exhibit A, which Rachel is furiously highlighting as I speak, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th, 2024. The rough transcript was helpfully provided by this court. That means the new judge, right? The new judge handed it over to defense counsel, as she should, by the way. It's refreshing that judges will, do the right thing. She comes across, oh my gosh, there's this other one. Let's go ahead and hand this over to the defense, and we need to deal with this one as well. A reading of the rough transcript highlights that which has been obvious to all observers, except for Kendrick's counsel for the past 19 months. Now, what does he mean? It's been obvious to everybody except himself for the past 19 months. Well, I'll let Doug speak for himself. This is what Doug is talking about.
What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot.
All right. So that's what Doug is talking about. He says, apparently everybody saw it but me, and now it feels like an idiot. I think if truth be told, Doug probably saw it too, but he's self-deprecating in that way. Glanville has been willfully biased and acting as a member of the prosecution team since the inception of the case. Kendrick's counsel takes no pleasure in alerting this honorable court to the situation, but obligations to the client require it due process, and a fair trial requires it. It's not a fair trial when in an ex parte meeting, Glanville, prosecutors Love and Hilton gossip like yentas. Anybody know what a yenta is? Tell me in the chat. I don't know what a yenta is.
It's Yiddish for like a gossip.
Oh, okay. It's Yiddish, you say?
It is Yiddish, correct.
All right. So I didn't see. I learned. We're here to learn, and even I learn stuff all the time. All right. So they gossip like yentas over 13 pages of transcript about attorneys Sharp, Melnick, and Steele. It is not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney John Melnick, attack his integrity, alleging that he is not acting in the best interests of his client, Mr. Copeland. And it's not a fair trial when, in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It is not a fair trial when, in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. Now, in case you are just getting up to speed, there is no love lost between attorney Melnick, who formerly usually used to represent Woody and Prosecutor Love.
And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth.
All right. So he is upset too. And they're apparently, according to this new filing, they're talking about him in this newly revealed ex parte. And he goes on to say it's not a fair trial when in an ex parte meeting, Glanville starts talking about outside agitators, stating, my comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have anything to do with y'all's case. It really shouldn't, but I think it does in some ways, outside agitators. Now, so here, think about this. This is in the judge's chambers or somewhere not in the courtroom, and you got the trial judge talking with the two prosecutors and nobody else, talking to them about the comments that he made in court. So he's talking about the substantive proceedings that went on in court. I can't begin to tell you, in my opinion, how unlawful and improper and unethical that is. It is not a fair trial when in an ex parte meeting, Glanville and Love have the following outrageous conversation. The court, but I think it does in some way outside agitators, Miss Love, that too. And then the court says, and everybody else who I think are trying to influence, Miss Love says that's absolutely happening. It's not a fair trial when Glanville, Love, and Hilton have this further discussion. Hilton says there's a lot going on. Miss Love says there is a presence. Yes, that is all I'll say. The court, I mean, I see it, but just from being in the courtroom and tracking. So Doug asks, how many violations of the Code of Judicial Conduct does it take to get a mistrial with prejudice? This is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed and more rot is found underneath. No Herculean effort by this court can fix the due process violations of the last judge. This house must be torn down. I love this colorful language. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. And we've talked about this word goaded. It's a legal term of art. If the defense is basically forced into it, into asking for a mistrial by prosecutors, or in this case, the prosecutors and the judge, then there would be no mistrial. There could be no retrial due to the double jeopardy clause. So he goes on to ask the judge to declare a mistrial based on at least the due process violations of Kendrick's constitutional rights under the Constitution of the United States, Constitution of the State of Georgia, and attaches the rough transcript that was given to the parties, I guess, by the judge last night. Rachel, what do you say?
So really quick, I want to say that, like Doug, I mean, I feel like I've defended Judge Glanville because I've had experiences with him where I didn't realize or didn't see these kind of ex parte communications, and I would kind of like excuse some of his behavior. Like I couldn't believe it. When I read this transcript, I was shocked. I feel like there needs to be like a search warrant of Adrian Love's phone. I want to know the text messages that went back and forth between her and Glanville throughout this trial. I don't believe that this is it. This is what was caught by a court reporter.
Now, do you think, is there something in this transcript that leads you to believe that there's those kind of texts and things going on?
The familiarity with which they're kind of discussing as a team, like they're huddling to come up with ways to get around certain aspects of the case, one being that Copeland was represented at the time that Miss Hilton approached him and started basically threatening him into testifying, or else he would be in jail.
And lawyers, by the way, we're not supposed to talk to a person if we know that they're represented by another attorney. We're supposed to contact that attorney. So the prosecutors aren't supposed to be talking, even with a subpoenaed witness. If they're represented by counsel, the prosecutors are not supposed to talk to them without going through the lawyer.
And it really makes, I mean, as I'm reading through this transcript, basically they start saying that it was actually Copeland's obligation to formally tell the prosecutors that he was represented and didn't want to talk to them. I don't know whether that happened, but I do know that Melnick reached out to them and let them know that Copeland was represented by him. What goes on through this transcript, one thing that really bothers me is how they're gossiping with the judge, these prosecutors, Hilton and Love, gossiping with the prosecutor about how some of these witnesses are being represented by individuals who they think are like seeking out the fame of representing
Spotlight.
I mean, it's absolutely ridiculous talking about how like they're trying to beat outside influences, and the judge is like, yeah, I see it too. Just not respecting the fact that witnesses can and are in fact represented. Trying to find any way for them to influence Copeland into testifying without counsel present, claiming that they're concerned about the counsel that he has. My favorite, I mean, we can go through the whole thing. It's just,
well, tell me what page you're on and I'll turn to it. Tell me, you're talking about your favorite. Where are you reading?
Let's talk about 5. We'll go to page 5 of this.
Page 5. Well, I may not be on the right place.
Wait. Keep going. 1.
Oh, page. Okay, I see what you're saying. I'm looking at my PDF pages. This
right
page 5.
At the
All
top
right, that's right. We'll get it together here in just a minute. Okay, go ahead. I'm on the right page with you.
So Miss Love says, Mr. Melnick told me previously that he was not representing him. I have no reason to believe that that's true. Especially because Melnick got up there and said that, Adrian was a liar. And I believe him because she is a liar. The court says
this is all the part of the conversation that's going on in chambers without the defense knowing about it.
This is shocking to me. The judge, back to Miss Love, says you would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact their lawyer.
Okay.
And then Miss Hilton, it's like, I don't know, like Tweedledee and Tweedledum. Whatever Adrian says, Simone, Miss Hilton just kind of repeats. Mr. Copeland would have said, because I don't know as a witness and he's not charged. So now they're saying that because he's not charged, they didn't know.
So they're having this discussion with the judge about why they may or may not have gone through his lawyer.
All the reasons that they didn't, including that Copeland didn't, he wasn't a defendant. So they didn't know because his lawyer hadn't filed an entry because there's no case to file an entry in. And they basically, and one of them claims that actually that Melnick told Miss Love that he actually wasn't representing him, which is not true. And then she says, we would have left. Okay. And the court says, Mimi, she wants to participate. Mimi girl. Okay. She said, because people counsel that they have under retainer or something. So you can I represent some of the wives and girlfriends of defendants in this case. So, hey, I have a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking with you unless my lawyer is present. So now they're basically saying that he has to specifically plead the 5th, even though these prosecutors know that he's represented. And that's kind of neither here nor there because they have ethical duties as well. But again, we're just here gossiping about what everybody else is doing wrong.
Well, in case anybody wonders, why this is a problem, at the risk of cluttering up the screen too much, actually, I'll just remove. This is what the Georgia law says about ex parte communications. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or an impending matter subject to the following exceptions. And then it goes on to talk about scheduling, administrative purposes, emergencies that don't deal with substantive matters, and so on and so forth. So we'll bring Rachel and I.
Yeah, and also when the reason believed that that one of the parties wouldn't gain a tactical advantage by the ex parte communication, and here they're actually like huddling together to figure out how they're going to get a very reluctant witness to testify. If we go down to the next page, this is also just fascinating. I can't believe we have all of this. So it's Adrian lying, more lying, and then it says, Miss Hilton explained to him, so we can go down to line 16. Miss Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking about with him, the statute of limitations has run. He didn't do the murder. We know that. Okay. I actually, if anybody, you don't have to be a lawyer to know that the statute of limitations on a murder, there is
no statute of limitations on a murder.
Claim that that the statute of limitations has run.
Yeah.
He didn't do the murder.
That's horse shit.
I mean, that's a lie. I mean, these are lawyers talking about this because I believe that Mr. Copeland at some point said, I did all this. And so they're saying that we don't believe you, even if you did. Okay. And so they're just kind of going back and forth, just gossiping. I don't know what time this actually happened at, but okay. So then we get to Miss Bumpus, and they take issue with the fact that I guess Miss Bumpus knows some of these defendants. I do too. If I could hug Young Thug, I would go in and hug him. Why not? But it says, I believe in conveying to the court that Miss Bumpus is going to take stand in his stead, meaning replace Melnick. And she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the room trying to hug Jeffrey Williams. Miss Hilton says, no, she was hugging. I mean, are we in 6th grade? She hugged DeMonte Kendrick.
So they're literally in the judge's office or wherever. They're not in the courtroom. They're talking about all the things that are going on related to the case in the courtroom, out of the courtroom. There's nothing, in my opinion, I can't find anything proper that would justify this kind of ex parte carryings on.
What does it matter? I mean, it really doesn't matter. And then Miss Hilton corrects her. Yeah, she hugged DeMonte, and Miss Love said, oh, I'm sorry. In fact, she hugged DeMonte and hugged Mr. Williams. And that's how Captain Kendall, who I believe is probably one of the sheriffs, saw her and had her taken out. And
I think what in the we got a lot of folks very active in the chat. I love to see it. We got 1,374 people in here. Hit the like button, please, if you don't mind. That'll help others find this channel. But I believe Transplanted Texan, one of our mods, has this entirety of this document and is going to post a link to it in the chat. And so if you're interested, I think maybe you can find it. And read it for yourself, tonight or whenever you have time, if you're just interested. But we're doing our best, Rachel and I, to hit the high points for you. But Rachel, this is crazy. This is
Mimi's still talking. I have a very,
well, that's okay. We're dog friendly here inside the law.
We're a vocal crowd. Mimi, be quiet. But so then Miss Love says, she starts talking about how she's expressing concern that Mr. Copeland, all of a sudden they're concerned that Mr. Copeland's interests aren't being properly represented. Since they have his best interest in heart. I mean, I find that so despicable. For them to be now saying that the people representing him, we don't like how they're doing it. We don't really even accept the fact that they are, because we're trying to go around them. And they're not actually, it is, she's half German Shepherd, half Bloodhound, Cheryl. So yeah, she just can't be quiet. But anyway.
Well, you know what you do if you've got this if it's a real concern, you file a motion to disqualify the lawyer. You have a hearing on it in open court where everybody's there.
And then you kind of go down, and she says, Mr. Copeland has been reaching out to Miss Hilton, and that communication is being blocked by someone who Mr. Copeland didn't reach out to. So again, they're taking issue now, these two prosecutors. It's not their business how a witness comes to be represented. He's represented. So at first it's that we don't think that they're acting in their best interest. Oh, they actually sought out Mr. Copeland. And she said, no, you notice no one said Mr. Copeland called me. I mean, why would I have to explain to the court how I came to represent a client? He never said, when we put on the record what Miss Hilton had said. The way I understand it, Mr. Melnick reached out to Mr. Copeland because the first time we heard the assertion that, oh, he's going to plead the fifth, it was when Mr. Melnick sent an email to Miss Hilton, myself, and copied Mr. Steele and Mr. Shard. And then again, the court gets in. It's like he's just part of the gossiping crowd. Why would he have done that given? And that's the state's concern, says Miss Hilton.
All right. Well, so this this is ADA, Assistant DA Love. And for those of you who may have missed the intro to the show yesterday, this prosecutor got it handed to her by the judge related to her duty of candor to the court. All lawyers have an obligation to be candid and truthful. Basically, that's what that means. Truthful with the court at all times. Look at this.
In a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms.
Your Honor,
Love.
respectfully, I take it very seriously.
Okay. So.
Something tells me the judge doesn't believe that she takes it all that seriously, Rachel.
No, but that's not even, that's like a little, like, you know, smack on the butt. Like, that is not, that her lack of duty of candor needs to be addressed a lot more directly.
Well, maybe, but this, my point is this is the person telling all this to the judge back in their little meeting in the office or whatever.
Yeah. And so this continues about how they're talking about if Mr. Melnick, we're still on page 8. He says what he did was he looked over at 2 people and said, I did what I could. So their concern, apparently, Miss Love and Miss Hilton, is that somehow through John Melnick and Kayla Bumpus, that the defendants are influencing Copeland not to testify. Okay. They haven't threatened him at all. Meanwhile, Hilton and Love are threatening him with being in jail till all the 26 people are tried. Okay, well, yeah, this is the best page. Don't go anywhere. Here we go.
What page?
You're right where you were.
Okay. All right.
Page 9. So, okay, the court says, well, there's a lot of innuendo. They have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process. And then Ms. Love says, well, that's my concern with Mr. Melnick's insertion of himself. Judge responds to her, what are you asking me to do? What are you asking me to do? And what do you think I can do? Why are they teaming up to do this? Here we go.
Well, why isn't this emotion being heard in open court?
It's not even emotion. It's just complaining.
I know, but if you have this concern, you file a motion to disqualify. Maybe you talk to the lawyer first, and if you can't work it out, you file a motion to have him recused or you have him taken off the case due to a conflict of interest if you believe you. But you have a hearing in open court and let him present evidence or testimony, and you let the other people involved in this trial, namely all of the defendants and their lawyers, you do this all out in the open. I mean, this is not a medieval star chamber. At least it's not supposed to be.
It is. And so please read the next part because I can't handle it.
Okay, Ms. Love, that's the exercise. That is the homework for tonight. I wanted to give the judge homework. I wanted to let the court know that that's what we're looking into right now, because there is a remedy, because I have faith in our law. I love this thing. There's a remedy, because this can never have been the first time that's happened. It has been addressed. I just have to find it. Yeah, it's called a motion to disqualify the lawyer for a conflict of interest. If you think that's what's going, if you got evidence and you can prove it. Anyway, she goes on to say, but I didn't want to be looking for something and not let the court know what I'm looking for. Well, why not? Do you share everything that you do with the court? All right. What I'm looking for, so that you are not caught off guard, Judge, when Monday morning or Saturday night or Saturday afternoon, we find it and we send it to you. Are they having ex parte emails or texts, or what's going on the weekends, Rachel?
It's so hard for me to say this because I didn't realize that Judge Glanville was so entrenched with Miss Love, but the fact that he's saying to her, what are you asking me to do? What are you asking me to do? And what do you think I can do, without the defense present to argue what he should do and what he can do? It just blows my mind. She says, that is the exercise. That is the homework. Are you my teacher? I guess it's just me, guys. I'm taking over right now. Here, he's coming back. Okay. No, I mean, to me, that dynamic, the dynamic where you have the prosecutor giving the judge homework and he's just simply asking, what can he do to help them? What are they? It doesn't, the whole thing doesn't, it doesn't make any sense. There was some situation where within here, I don't know where it is and I'll have to find it, but they're talking about being really concerned about Kenneth Copeland's freedom, about how they don't want him to be in jail. And they're just liars. And I'll tell you this, I was watching yesterday. I was watching court. Well, I was there today.
I have lost, I don't know if y'all can hear me or not, but I have lost audio. So Rachel, keep going over. If you nod your head, if you can hear me. Can you hear me? All right. I want you to keep going over the motion as you see it. I'm going to keep the stream going. I'm going to readjust something and I will be back.
That's fine. Perfect. Okay. Now the substitute teacher's in town. Here we go. Hopefully my dog will behave. But what I wanted to say is that the judge specifically asked how many ex parte meetings were there yesterday in court. And she asked the defense how many they've had and like what was the context, asked the state. This June 7th transcript that occurred before the other one that was released about with Kayla Bumpus and Copeland and the judge, the state did not mention this yesterday, even though clearly it happened. It's another lack of candor to the court, just unbelievable lying. And so when she starts talking about how proper it is to keep them on the case and how nothing that they did was wrong, they're lying to the court. That they have a lack of a lack of candor when they have a duty to actually be truthful to the court. So I was telling them, Phil, can you hear me?
Yep.
Okay, no. So I was telling them that the judge specifically asked about all the different ex parte meetings that had been had that might be of interest to the opposing party. This June 7th situation was not mentioned. They asked the state. She didn't say, oh, yeah, we also had one on the 7th. But as Max Shard explained, this provides the context for what happened on the 10th, which we've had that transcript for a bit. They were clearly getting together to figure out how they were going to get around Melnick representing Copeland in a way that they didn't think represented his best interest. I don't believe she mentioned it because I was watching too, but bottom line is she told the court that she didn't think that he was represented. They waited until Melnick went out of town. They took advantage of him having a new attorney the next week. But we see the setup. The judge says, what can I do? There must have been some kind of communication over the weekend between her saying, do your homework, and Monday having another ex parte meeting. What could they do? They could have another ex parte meeting and try to threaten Copeland into testifying. So I guess it's just me, guys. Adrian Love is one of my favorites. I don't have the, there you are. I don't have the actual transcript up, but Adrian Love is talking about how she cares, just the idea of someone sitting in jail throughout this trial. If that's what he's being counseled to do, that's just wrong. All of a sudden she cares about people being in jail pending trial.
Yeah, I apologize. So people, I do keep dropping, and I've been trying to have some kind of a glitch on my end, and I'm just popping in and out and letting Rachel carry on. Rachel, can you still hear me?
Oh yeah. I can hear you.
Yeah, you're doing great. Look, you're here because your whole reason for coming in tonight was to bring us up to speed on what happened and to go over this transcript. So
yeah,
don't mind me. I'm just got a little technical difficulty on my end, and we got some weather in the area too. So
yeah, and this is actually something that kind of bothered me today with Judge Whitaker too. They're concerned, Judge Glanville and Judge Whitaker are concerned about outside agitators and I was sitting in the courtroom today. There's no agitation. There are so many limits on who can come in the courtroom. You have to put your phone away. Even if you're a lawyer, I'm not allowed to have my phone out. It's a public courtroom. They forget that I understand that it's the state's choice to try 6 people at the same time. Some, high profile defendants, but they're acting like, it's a case of public interest, which is why people are interested. And they're kind of like making it seem like everybody wants to get in because they want the attention from it. This thing's been going on for like a year and a half.
All right, let me show you. Let me play a video, Rachel, and I want to talk to you about it on the other side. And we're going to talk about what this means in
after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right, well,
All right. So I want to explore that, and I'm going to get Rachel's comments on it. But first, I want to say welcome to the now 1,580 people that are joining us. And if you're just joining us, this is Inside the Law, where we take you inside the real justice system so that you can learn sometimes the unpleasant truths. And one of the unpleasant truths about it that you just heard from Doug Weinstein, at least in the state of Georgia, we don't do trial by ambush. We're supposed to be entitled to have discovery. That means everything that the other side has, and there's certain rules about it. But under Georgia law, prosecutors are they don't really have to give you anything until 10 days before trial, if you can believe it. But if you have a judge gives like a scheduling order and they say that, all right, you want to have this turned over by this time and so on and so forth, judges can do that. And if this were a civil case where only somebody's money was at stake, then that evidence can be excluded. But in a criminal trial, they let everything in, even if it comes in late. And you don't have any depositions. They can't depose these witnesses. You know, if Rachel crashes her car into mine tomorrow and we sue each other, we can force each other to go to our lawyers' offices and give a deposition under oath about why Rachel ran the red light or whatever, or why I didn't run the red light. Of course, I would never run a red light.
It's probably me. No, I didn't.
But you don't get that kind of discovery in a criminal case, and that's part of what Doug was frustrated about. Rachel, what is your take on that?
I was telling Doug's client's mother, I was sitting outside with her today. You know, what I love about Doug is that he really, I think he has a very good compass as it relates to what's fair and what justice means. And as somebody, you know, I think when you practice criminal law for a long period of time, you kind of become jaded. You kind of just expect the law doesn't matter. I always joke that the way that the state argues, if that's how they answered the question on the law exam, they would, do very poorly. But in court, when you have judges that don't really care about fairness, the law doesn't even matter. And you just watch your client's rights. You watch the law just be completely watered down such that your rights don't matter. And Doug just does an amazing job, both in writing and in oral advocacy, of presenting to the court the reasons why it's so unfair, reorienting everyone to what's real. He's the best. And the judge did mention, this is what bothers me too. I like this judge more to handle this case than Glanville, but I will say, there's no real teeth to her, her bites at the state. She talks about how she doesn't want this to be a trial by ambush. So Doug did phenomenal today. Bruce Harvey made a motion to exclude all statements that the state was intending to bring in by co-conspirators, meaning people who were not charged in the indictment as defendants, but who they believe are co-conspirators. Apparently, in November of 2023, Judge Glanville ordered the state to actually list for the defense all of the statements, jail calls, wiretaps, all of that they were going to be using potentially in this case, in their case in chief. They presented, I believe, three statements. Today, Bruce Harvey said, if there's anything else that they're going to try to bring in, it should be excluded. The judge said, well, the state, how many other statements do you expect to bring in? And I don't know the guy's name who sits between Miss Love and Miss Hilton, but he gets up and he's like, well, if I had a ballpark, it'd be at least 50.
Oh my gosh.
50 other statements. And that's just within, I believe, one wiretap.
We're going to be here until 2027, it sounds like.
That is trial by ambush. The problem is, it's like 50 statements. Yes, they turned it. Basically, in this case, there is voluminous discovery, meaning hundreds and hundreds and hundreds of jail calls. And what the state likes to do, this is Adrienne, this is one of her war strategies, is that she likes to basically dump discovery on you and then not tell you what she's planning on using, so that you're kind of unprepared. Every time I talk about her, my dog says, yeah. That's what's going on over here.
Well, let's go ahead. Let's finish that thought. Then I want to raise another one.
Yeah. So now the judge is basically saying, and Bruce, the good thing about this judge too, is that she really likes Bruce Harvey. I think she really likes Doug Weinstein. She really likes Brian Steele. So when they talk, she does a lot of like giggling. I think it's kind of nervous giggling, but she does seem to listen to them. And it made me feel better, because when Bruce was explaining this to her, she kind of looks over at the state like, I mean, what do you mean? The judge told you to do this. This is what the state is used to. They're used to being ordered to do things, then they don't have to do them, and then there's no consequences.
No consequences.
Okay, now you can say whatever you want. I'll be quiet.
All right. Yeah. So, all right. I want to take a minute. And by the way, thank you for the super chats. I want to just go through some super chat questions here real quick. IG, thank you for the super chat. By the way, these super chats are very helpful, because this is how that kind of support for the channel and other types of support helps me to continue to bring new and additional and hopefully better content, maybe without the tech problems that I've had tonight. But I think some of that was weather related, but at some point, my hope is to do this more frequently and do my actual practicing of law less frequently. So this type of thing really helps push me in that direction. So thank you very much for supporting the channel in that way. IG asks, how's their trial proceeding without the judge ruling on the mistrial? She's talking like she won't grant it. Well, so my thoughts before I get Rachel's, my thought is, I think she might grant, she's denied some of the other ones, but I think she might grant Doug's, because Doug seems to be on to something. He filed this supplement. He's raising the issue of this newly revealed ex parte, which there can be, in my opinion, no justification for it. And for the reasons that, like Rachel just went through going through the transcript, it shows that they are talking about matters of substance related to this trial that needed to have been done in open court. So, I don't know if she's going to grant it or not, but I think that, if you asked me yesterday, I would think that the prospects for a mistrial were on life support, but they've been given some new energy today with this motion and this filing by Doug. What do you think, Rachel?
When the judge used the term trial by ambush, I kind of, my eyebrows went up like, okay. She also said something like, if this trial continues. She was talking to everybody, and she was saying, if it continues, as though it's still up for consideration to mistry the case. Again, it just gets uglier and uglier for the state to have all this come out. And mind you, Judge Whitaker worked in the same office as Adrienne Love. She was a supervisor at the Fulton County DA's office for many years while Adrienne was still there.
Interesting stuff. Well, that, that could cut both ways, but all right. So thank you very much for that. And then, 30-yard wink. And thank you for the, Canadian super chat. Really appreciate that. Here's my Canadian take. The judge will grant a mistrial. That's why she's not granting other motions, but is making a strong record of the terrible case so far, so it holds on appeal. And she congratulates you, Rachel. So, Rachel, you go first. What is your response to 30-yard wink's take?
I think it's hopeful. As a criminal defense attorney who practices in Fulton County, I become a little bit more jaded and cynical. But if you're applying the facts to the law, at least these prosecutors should be disqualified. But I think a mistrial with prejudice makes sense. It makes the case is a zoo. I think Adrienne started off in her opening statement talking about these are the laws of the jungle.
Oh my gosh.
Created by her. And what has happened thus far, as Doug said and Max Shard said, you can't start giving people a fair trial at witness 76. That's not when you start. It has to be all the way through. And you can't look at this case and think that they've had a fair trial thus far.
Well, I mean, I agree they haven't had a fair trial. I agree with all of that. My take is I think she might very well grant
Can you? Oh, we're back. No, we're back. We were revived. I don't know where he is. Here he is. I think I'll be interested what he says. Come on, Phil. Thank you for all of the love, everybody.
All right.
Okay, so you were saying that he
So can you guys still hear me? I want to look in the chat to see if you guys can still hear me. It looks like it's showing me that I'm online. Hopefully you guys can hear me. All right, thanks. Okay, so we're back, and we have some weather near here that oftentimes affects the internet. So I apologize for that. But anyway, we've switched sides. Now I'm on the left, and Rachel's on the right. But we were still talking. Rachel, can you hear me?
Yes, do-si-do. I don't have the weather. We must be farther apart. I'm going to ask. I'll answer questions if I can. Let's see. I don't know where he keeps going. I kind of feel like I'm a teacher in charge of the class, but I shouldn't be. But let's see. I saw some other really good questions. And I don't know if Doug is in here. And I'm sorry to not, I forgot to mention that Yentas are usually women, but that is true. Yeah, I'm the substitute teacher. You can misbehave when I'm here because I don't punish people. I also wonder if Glanville, I'll ask you, Phil, I wonder if Glanville's like been in court, like if he's like down the hall.
I think he's probably watching it on YouTube. I put in Prophecy Breakdown says, one defense of love, just one. I think the homework reference was about what the state were working on, and it was not an assignment for Glanville. Maybe so. Again, this is just a cursory read of that transcript, but the whole point is that ex parte had no business even occurring in the first place. And Owen Thornton, thank you so much for the super sticker. That kind of support goes a long way towards helping the channel. And y'all, I promise you, I've got direct wired internet into here. So it's, I'm doing my parts. All I can do is say I'm sorry about the connectivity, but we're all back in here now. And so we'll work our way through it. Rachel, you got anything you want to add? Do you see any other questions that you want to?
Prophecy Breakdown was, I think he asked something that I thought was about the homework. So if the judge hadn't just asked her, what can I do? What should I do about this? I know she's saying she's trying to look for case law, but he's offering to do whatever she asks without the defense having a chance to even respond or suggest that what she's asking for would be unreasonable and wrong, which is what we know happens that following Monday where they have that long ex parte without having any, giving any deference to the fact that Melnick was out of town. I can speak for John Melnick is definitely not involved looking for clout.
No, and he's just the nicest guy you ever meet too.
To make that suggestion, he's actually a really hardworking, great defense attorney who works. And so to even say that to the judge makes me sick. And then they're taking issue with Bumpus. And I'm surprised they didn't say anything about me. But they just wrong.
Sea Travel is asking, why was the judge giving prosecution law 101 class today, Rachel?
Because they need it. God, no, I mean, it's because they need it. But I mean, apparently they're all in class together.
All right. Another super sticker. Thank you very much for that. Marcep, if I'm saying that right, really appreciate that. I had another video that I thought was pretty interesting. Check this one out.
Never taking Miss Love's proffer. Okay, so she says that I said, I don't talk with Miss Love, by the way, if you didn't know that. So I never said anything to her. But that I said.
Is there somebody on the state's case that you are able to talk to?
Yeah, Miss Willis.
All right. Well, okay.
So he doesn't talk to Love. He says he talks to Fani Willis.
This case has, I think, opened the eyes of many great defense attorneys into just how low Adrian Love is willing to go. And the fact is that even though he can talk to Fani Willis about the case, Fani Willis defends Adrian Love and did in a filing recently, talking about how the ex parte meeting was proper. She underlined it. She bolded it like it made a difference. And what I responded to that is that anything that the Fulton County DA's office has no business deciding what's proper and not proper at this point, because they've demonstrated how far off the rails they've gone. Brian Steele, Brian Steele tempered. He's an incredibly peaceful advocate as things go. I mean, Bruce Harvey gets a little bit wild. Max Shard gets a little bit wild. But when you get people like Doug Weinstein and Brian Steele riled up like that, there's something really wrong going on. I mean, she riles me up, but that's to be expected. But these are lawyers that are really even tempered, and they can't even have a conversation with her because she's so unbearable. I think Max Shard said today that his bald head has been sweating all weekend. I mean, she really has this effect on people where she will make you want to pull your hair out. If you don't have hair, you're just going to be sweating. Makes you feel crazy.
Blurry Lights, thank you for the super chat. Can Doug say how he got that new transcript? Just curious. Yeah, I think that it's not really a secret. The judge apparently became aware of it, and she had this. I guess asked the court reporter to put a rush on it, but that's why it's a rough transcript. It's not like an official transcript yet. But the judge, I think, handed it over to all of the lawyers in the case. That's my understanding. And Rachel, do you see it a different way, or is that about right?
No, I think that's about right. The last page of it, for better or worse, with the Caleb Bumpus situation, I just want to say that Miss Love goes on and on. The last part of the transcript, she says, so Miss Bumpus is going to be here speaking about, this is a Friday, talking about the following Monday. Miss Bumpus hugging Mr. Kendrick and Mr. Williams. She's going to be here representing the interests of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. And that's
what
where
page are you on?
Right there. That's where we are. That doesn't pass the smell test. Lines 24 and 25. Adrian Love talking about what does and doesn't pass the smell test.
There's just nothing about this ex parte that's arguably okay. It just can't even. It's just not even close.
No, and I've had situations. Adrian just loves to misuse the law, and so and that's why telling her that she should take her duty of candor more seriously. I mean, she can take those hits. She doesn't mind being like, well, I do take it seriously and moving on. There has to be actual consequences. That's what I'm about for her. I'm not a prosecutor, but she's the only person I want to prosecute.
And I agree with this comment from Prophecy Breakdown. To be clear, if a mistrial isn't granted, I think justice does require. I mean, I've thought that a long time. I thought it required it a long time ago.
Okay, and really quick, Phil, what are the jurors doing during these weeks off? You have to imagine they're watching some of this. They know that the judge has been removed that Judge Glanville has been removed from the case. They have to know the reasons why these transcripts are publicly available. And at this point, I feel like if I were one of the, well, I don't know, I guess it's a strategic decision. I would want every single, it's a shanda. That's right, Fletch.
What is a shanda?
It's another Yiddish word. It's just like a, the word's escaping me. A shanda is basically it's bullshit.
Okay. Thank you, Fletch. See, I'm learning. I love learning from the chatters. It's amazing how much you can learn.
Yeah.
So you were in the courtroom today. I wanted to ask you, what was it like? What was the vibe in there like compared to what it was like when Glanville was on the bench?
Well, today the judge wanted to get moving on things and nobody was really ready. And she was kind of upset with the attorneys for not taking this time that they've had off to do the things that she thought that they were, that they should have done. But then here she goes. Then Doug Weinstein, thanks, Mimi. Doug Weinstein got up there and was like, I have tons of other cases. So I spent that, Mimi, there's dogs walking back. No, she's so bad. We need training, but we don't believe in obedience in this house. Watch out for my child.
Your child will have that dog eating his paws in no time. All right. Vibe has to be like what I've noticed, Rachel, is I've noticed that the prosecutors are taking a very different tone. They're using their inside voice, so to speak, and they're not talking to her the way they did Glanville.
They're treading a little more lightly. And sometimes I'll watch like a crime show and I'll be like, they got to get a female investigator in there to talk to that woman because woman on woman is different. And so Adrian seems to be a little bit more, a little bit more reserved. I mean, she still talks back to say to her, well, respectfully, I do take my duty of candor seriously. I mean, some judges, if I would have said that to a judge, I kind of feel like I would have gotten some, you don't need to, it wasn't for you to respond. But I do think she's not going to be able to text the judge over the weekend and have these kind of conversations.
Apparently not. Well, if I'm the judge, if I were the judge, I would be digging deeper into this. I mean, were there text messages going on, emails that are all ex parte? What I would want to know. But Strom asked, Sit Room, I'm sorry, I didn't read it correct. Sit Room is asking, does this DA's office think RICO is a prosecution strategy? Well, they like the racketeering charge. You saw it in the Trump RICO case. This is a RICO case. Fani Willis herself, when she was an assistant district attorney, used RICO in a massive case involving the Atlanta public schools, where they indicted half the school teachers in Atlanta for racketeering related to standardized testing. So that was years ago. And so it is something that she likes to use. And she has liked it for a long time, long before she was the elected DA.
Yeah, I feel the same. I mean, that there's at least four other RICO cases going on, and it's because they think that they're going to be, able to get in more evidence. So, for example, the co-conspirator statements, the Judge Whitaker said today to Bruce Harvey that if it's like a co-conspirator in a RICO case, they don't have to provide it to you. There's certain advantages, kind of like the gang charge. There's certain ways that you can get around evidence that would otherwise be excluded. You can get it in a RICO case and get it in a gang case. So they just try to make these cases bigger and bigger and bigger instead of actually proving what they're supposed to be there to prove, which they've really lost sight of that. And the jurors have to know. But what I was saying earlier is I wonder if you polled the jurors, if it would make sense strategically to poll them as to what they've discussed with their families and what they've seen in the news while being at home. I think some of these defense attorneys think that they're winning, as they've told the court. And so they don't want to do that. They don't want the mistrial. And so maybe it wouldn't be strategic to do that. But if you wanted a mistrial, just ask to poll the jurors. That's what I would do.
Why would a defense lawyer not want a mistrial at this point? Strategically, to me, I don't see an advantage in not wanting one, unless you just are 100% sure you're going to win.
I don't know. I mean, I'm kind of with you. Like I would want a mistrial, but I also wouldn't want to start over with a new jury and have the state benefit from streamlining their case. Like if the state gets another go at this, I imagine they'll do some things differently. But
they would do a lot differently with a new judge. Absolutely.
I wouldn't want them to have a chance. So that's the reason why you wouldn't want it. But at the same time, these jurors are clearly watching this, and that helps the defense.
So for some of the people who are joining us late that were not here when we first started this live stream, I want to play you this video again. I call it Mad Max, and I think Max here encapsulates the exactly where the state of the trial is right now.
This is disgusting, but it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need.
Yeah. So if I'm not mistaken, Max he's right about everything, but he's also said that they didn't file a mistrial. And I'm sure there's a strategery there to that, and probably for the reasons that you just pointed out. But Max, I think, did a really good job of basically encapsulating everything that has gone wrong with this case and where it is now.
His anger is completely justified. And
100%.
even the judge kind of says, like, I can see that, and she understands. I don't believe the judge has ever done any defense work, but she does. I know she was a prosecutor, and I believe that her reputation as a prosecutor was a lot better than Miss Love's. And there are people that work in the office with Miss Love that don't appreciate what she does and that don't believe that what she does is okay. And I think that kind of like they probably turned a blind eye to it when they were in the same office, but now that it's being presented to them this way by defense attorneys that she respects, it's having a real chilling effect.
Tiffany asks a good question, and thank you for the question and for the super chat, Tiffany. And this is referring to Hilton's vacation. Now, before let me back up for a second, because right around the time they were having these ex partes and getting ready to throw Woody in jail and threatened to hold him in jail for, I guess, the rest of his life and until the trial was over, which one ever came first. Jonathan Melnick, the attorney that was referenced in this transcript from this ex parte that was originally representing Mr. Copeland, he had a pre-planned trip with airline airfare and things already, booked and paid and planned long on the books before all this. And so he wanted them to kind of work with him to schedule to make it where he could be there. But as I understand it, they wouldn't work with him or to accommodate his schedule, which is the only reason he brought in Bumpus as the standby counsel. So let me just tell y'all who don't know this, it's commonplace for lawyers usually, and courts, by the way, too, to try to accommodate the personal schedule conflicts of attorneys. They have to accommodate scheduling conflicts with other courts, but they try, because we try to be civilized people. We try to accommodate one another in things like that, because lawyers and judges, even prosecutors and court personnel, they have kids in school. They have kids go on spring break. They have travel, basketball, football, whatever. They have vacations and all this stuff. They're just normal life stuff. And judges usually try to accommodate that where they can, but they didn't accommodate Melnick. And so Tiffany is asking about Hilton having a vacation. Is that any indication that the prosecution anticipated a mistrial? I want to say no. I don't think the prosecution anticipated a mistrial, but I'm wondering why it's okay for the prosecutors to schedule a vacation when nobody else can. That's number one. And Tiffany says, and perhaps when the official transcript from the new ex parte meeting is released, mistrial will be granted. I don't think the official transcript, Tiffany, is going to be any different than this unofficial one. I think this was just a rush that the judge asked the court reporter to do, and there might be a typo or something in there that gets changed, but I don't think it's going to change in any material way. Rachel, your thoughts?
I feel the same way, but I do think the way that prosecutors are treated is very different than the way that defense attorneys treated. And what we know about them not really respecting Melnick's leave of absence that he had filed long before, I think months before he was supposed to be in court. The way that we now know that the state, along with Judge Glanville, felt that he wasn't representing Copeland's best interests, meaning the interests that they wanted to have for Copeland to testify to what they want him to, that had something to do with it. They weren't going to accommodate him because they didn't like how he was representing Copeland and the legal advice that he was providing him, because it went against what they wanted. And that's now clear. I do think that this provides context for the judge, for Judge Whitaker, this most recent ex parte transcript of just how deep this goes. These are transcripts that have been, put together by a court reporter. But if you think that that's the only time that the judge has talked to the state off the record, I know they're talking off the record. That's what that communication tells me. They are so comfortable, trying to.
I mean, it certainly looked like they were ready to have some over the weekend, and so it makes you wonder how many other times have they chatted over the weekend or after hours. It really does raise that question. Michael points out that Glanville should be gone, removed from the bench, and disbarred. And so here's what I'll say to that. The Judicial Qualifications Commission has removed judges for less than this. I mean, there is no legal basis that I can find for this ex parte. Love and the rest of them, they keep trying to mischaracterize this, Rachel, as some kind of hearing on granting the witness immunity. But no, it had already been granted. And this, when they went, and obviously the ex parte that we were talking about today had nothing to do with that. But then the thing on the Monday morning, the one that we already knew about, that was where the judge was literally reading the code book to the witness about, contempt of court and perjury and all these kinds of things. And so putting the heat on him, putting the screws on the witness to convince him to testify. And that's just too far. And there's no way that was any kind of legitimate hearing on anybody's immunity, because that had already been granted. So I think they were being disingenuous when they told this judge that was the reason. And Fani Willis even said that in her response to the motion to disqualify these assistant DAs. Willis herself filed a motion or a response to that, and cited that was the reason for the ex parte. And I think that's disingenuous. Not true. It's not truthful.
And I think any
decent odor of mendacity,
and any decent lawyer willing to look at this, a judge with any neutral mind will be able to see through that.
There's nothing more powerful than the odor of mendacity.
That's true.
Smell. She's got to smell the mendacity in the courtroom right now.
It's crazy. And I know they're not going to court tomorrow, but they're coming back on Friday because they're giving them time to, I guess, come up with whatever objections that they have to Copeland. But how does a jury unhear what they already heard?
Let's see. Love Move says they talked over the weekend between the 7th and the 10th. Glanville told them to tell them anything he could do. Okay, that's a good point. On Monday the 10th, the judge came in and threatened Woody with 2 years in jail. Well, you know what? That's a very interesting theory. So connect the dots. Maybe that was the discussion over the weekend.
Yeah. Meanwhile, they're pretending in the ex parte from that Friday that they don't want him to go to jail, and that basically Melnick, they're saying John Melnick, by advising his client to take the fifth, wants his own client to go to jail. But the only people threatening Copeland with jail would be the judge and the prosecutors.
Yeah.
Like,
and they were giving him permission. Basically, he says, we're not going to prosecute you for perjury unless it's a bold-faced whopper or something along those lines. And I'd like to know how they define that, by the way. I mean, how big of a lie does it have to be before they'd be willing to prosecute this witness?
Yeah, and there's no statute of limitations on murder. So when they tell him, we're not going to go after you for murder, even if you tell us that you did it, it's like, how can you take them at their word on that? It's ridiculous. And they can't say what's going to happen federally, because this is just a state court. So they can't give him the immunity that he would need in order to feel safe testifying. But they're talking about, they're concerned that they're not going to get their witness to say what they want them to say. That's what everything has been about so far from the state as it relates to Copeland. Boo-hoo.
All right, Rachel, I know you said you had somewhere you had to be right around this time. I wanted to say again, congratulations on, do you know what you're having, or are you going to find out?
No, but I'll let you, as soon as I know, I'll let everyone know.
Okay.
I know it's just one. I know it's just one, which was really important to me, because if it was two, I don't, it's too much for me.
Well, your life is about to change in strange and wonderful ways. Congratulations.
Oh, I thank you. And yeah, well, welcome to the world soon, my wild child. I hope they're wild.
All right. We're going to say goodnight to Rachel. We're going to continue our talk. Good night, Rachel. Everybody give her a big round of applause. All right. Look, I mean, that's great. I'm so excited for her. I think that's going to be amazing. My kids are all older now, but that baby stage, you miss it, I guess. All right. So, we have, let's see, what is this? We have, thank you for the super chat. USLD1 LLC, justice system symbol in this case, coming from the prosecution, is a blindfolded one with an unbalanced scale and a sword in one hand. I feel sorry for my kids. Forgive me. This, I guess the whole point, thank you for that comment, and thank you for the super chat as always. As I said, those are the ways that help me continue to grow this channel and perhaps one day be able to do this full time. All right. So your point is very well taken. I think that, what we're seeing and what's being revealed, and this is sometimes when we talk about, we look at the real justice system, and sometimes that means you look at the ugly underbelly of it. Sometimes you see things. Just wait until we start doing episodes here inside the law on wrongful convictions, things that go wrong in the justice system that cause people to go to prison for, long prison sentences only to be exonerated decades later, or whether they've been maybe executed and then we figure out that we got it wrong. So there's a lot of things that are the real justice system that a lot of you just would not feel comfortable knowing about. And we're starting to see through some of these cases, and it's honestly through prosecutorial overreach and overzealousness in these prosecutions. And when you see that judges sometimes go along with it or permit it, you start to see instances where the justice system breaks down. And when you have one breakdown in the system, you have a result that's not reliable. And that can easily mean wrongful convictions. Yeah. And innocent people can go free. Innocent people can be convicted. Guilty people can go free as well. But when the justice system doesn't work right, when prosecutors don't do their job right, when expert witnesses testify to junk science, things like that, you can't have any faith in the end result. And when you can't have faith in the end result, well, sometimes it's a blow to our psyche, because we grow up thinking that, courts are places where you can get justice. Well, I mean, what the hell is justice? What does that mean? And it depends on who you are and what your role is in the system, right? If you're a defendant or if you're a victim, or, you know, justice can mean different things to different people, but we get disillusioned sometimes when we see how things really, really work. But anyway, that's just my soapbox for tonight. Thank you very much for that super sticker as well. You know, folks, we're going to keep watching this case. We're going to keep watching other cases that are in the news, but Doug Weinstein told me today by text message, he's anxious to get back in here inside the law and talk to you about things from his perspective. And we're going to have Doug. And so we're going to continue to cover this case, and we're going to bring you the good, the bad, and the ugly about all of the things that are happening in this case. But, you know, one thing that I just want you to remember, going all the way back to the beginning of the case, this is what Judge Glanville said passed for regular testimony.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break. Hang in there.
All right, so that is the kind of testimony that Judge Glanville says passes for reliable testimony. And when you have people testifying under the influence and people's lives are at stake, I think right out of the gate, we saw that he was willing to tolerate a hell of a lot out of the state's presentation. And I play that clip a lot because it can be kind of funny, but it's also really kind of sad, because when people's lives are on the line, like the defendant in a criminal case, if you're putting up witnesses as a prosecutor who tell you that they're high as a kite, you can't rely on their testimony. You can't rely on it, but the judge was allowing it, and these prosecutors were putting it up. So right out of the gate, we saw the lengths to which they were willing to go, and it just doesn't go anywhere good. Anyway, I promise you I'm off my soapbox, and I want to thank all of you who've been here tonight from the very beginning, and those who are here now, and those who are watching on replay. Don't forget to hit the like button and subscribe. Help me get to that 50,000 subscriber mark. I would really appreciate it. But with that said, please don't be that guy we just saw. And until next time, I'll see you right back here inside the law.